Hi, Nan Jensen here. This video is for you if you have a disability and particularly if you have had difficulty understanding some of my other videos. Today's video is going to be about enduring powers of attorney, but first I need to do my disclaimer. The information in these videos is information only. It is not legal advice. You should not rely on anything you hear here. If you need legal advice, you need to speak to a lawyer and you need to tell them your whole situation, and they need to give you a letter of engagement which explains how you're going to work together, what work they're going to do for you, and how much they are going to expect you to pay. So again, don't rely on anything you hear here. You need to speak to a lawyer if you need legal advice. Okay, so enduring powers of attorney. The first thing we need to discuss is, what does that mean? A power of attorney is what it's really the words that it's called. So it's about giving away power, and it's you giving away to someone else the power to make decisions for you. And the difference between that and being a subject person under a welfare guardian order or a property order is, with a power of attorney, you choose who is going to make those decisions for you. With a welfare guardian or a property order, the judge chooses who's going to make those decisions. Now, enduring power of attorney is called enduring because it lasts for a long time and it lasts beyond the point where you may have lost the capacity to understand your own decisions. You are the donor in this situation. The donor is the person who gives away the power, and the attorney is the person who is given the power. So they become your attorney. They are going to act for you and act as though they are you. They're going to make decisions for you. So they have the legal right to make decisions for you once you have given them that power. So I hope that all makes sense. So that's why it's called a power of attorney, and the document itself that you sign to give them that power is called an enduring power of attorney. Now, there is a separate document called a power of attorney. It's a similar document, and I'm not going to talk about that in this video. So a lot of people seem to think that there's a big difference between enduring power of attorney and having a welfare guardian, and there is a difference, but it's really not that big, because both cases, somebody else has the legal authority to make decisions for you. The rules about how they are to behave are pretty much the same. And like I said, one of the really big differences is that in one case you get to choose who the people are, and in the other situation the judge chooses. The other thing is that a power of attorney has no expiration date. It doesn't finish at any time unless you choose to finish it. A court order, such as a welfare guardian order or a property order, those only last for either 3 to 5 years, or sometimes even less, depending on what the judge has decided, and then they are reviewed. So in some ways, a power of attorney gives more power away than the court order, because it's only reviewed if somebody asks a court to review it, or if you choose to change it. But if you don't do that, then it just continues until the end of your life. Now, you may have seen in the other videos, and also in my first video for people with disabilities, the one about welfare guardian and property manager, that there's a division between personal care and welfare and property, and that's the same with enduring powers of attorney. So normally you would sign 2 enduring powers of attorney, one for personal care and one for property. And the divisions are the same. So the personal care and welfare one is about decisions like where you're going to live. For example, if you need to go into a residential service or into a nursing home. Might be about giving consent to medical treatment, so signing the papers so you can have an operation. And the property one is about your property. So mostly that's money, but it can be other items that you own as well. So making decisions about that, having the authority to take money out of your bank account, paying your bills, that sort of thing. So if it's decided that you need to, for example, move to a new apartment, then the person who has the personal care authority will make that decision, but they need to work with the person who has the property power, because that person will have to pay for it. And it can be the same person that you appoint, or you can appoint different people to those roles. Now, you can only appoint one personal care and welfare person at a time, and it's a good idea to choose a substitute as well in case that person can't do it. With property, you can choose 2 people, and sometimes that's a good idea, and also to ensure that they need to consult each other, because there's less risk that someone will do something inappropriate if there are 2 people working together, and there are other protections that can be put into the document. Now, enduring powers of attorney are prepared by a lawyer and witnessed by a lawyer. The court does not get involved unless someone asks them to. So in court, it's the judge who decides whether you have capacity and whether you meet the criteria to have a welfare guardian or property administrator. With a power of attorney, the lawyer has to do that. And of course, neither the lawyer nor the judge are medical professionals. So it's helpful to get information from a doctor who can give an opinion on whether you are able to understand the document. It's not really a choice whether you're going to have a welfare guardian or give powers of attorney, because to have a welfare guardian, you need to lack capacity, and we talked about that in the first video. It's about not being able to understand the nature and consequences of your decisions. So not understanding the significance of the decision, what is it about, or what will it mean. In terms of being able to give powers of attorney, the most important thing is that you are able to understand what is in the document. So you don't necessarily need to understand how to manage your money. It may be enough that you understand that you need help with it. But you do need to understand what the document says, or else a lawyer will not be willing to witness it for you. Lawyers are not allowed to encourage someone to sign a document that they do not understand. So that's why it isn't a choice whether you're going to do one or the other. It really depends on your ability to understand your decisions, what you need help with, and to understand what's in the document. Choosing a power of attorney requires you to make certain decisions, and so in a way it's the same as the other evaluation. It's about whether you understand those decisions. Now, so one thing I was saying was it's good to get a medical opinion. So if your doctor is willing to write down whether they think you're able to understand the documents, then that can be really helpful for the lawyer to decide whether they're willing to witness it for you. I think a lot of lawyers would be concerned about whether they should witness a document for a person with a disability. I have done them, but I'm also cautious because it's very important that you have made your own decisions about who to give your power to, and that you understand what the document is about and what its strengths and weaknesses are. People First is an organization that has a website, And if you look there, you can see an easy read document about enduring powers of attorney. If you are going to do powers of attorney, it could be a good idea to download that document and read through it with a support worker. So you can, first of all, be prepared for your meeting with a lawyer, and you can start to make some decisions about who you might want to appoint to be your attorney. Now, how should you choose people to be your attorneys and to play other roles in helping you to make decisions? Well, obviously, you need it to be someone you trust. For many people, it may be their parents or their brothers or sisters. In other cases, it may be someone else. You should not be appointing someone who is paid to look after you. So unfortunately, you may have a support worker that you really like and spend a lot of time with, but that person is not an appropriate person to choose. They could be someone that is consulted, and you can ask for people to be consulted within that document, but it needs to be people that you trust who are not in a paid capacity. Now remember, you can choose 2 people for property. So that's another thing to think about. And again, it's always good to choose substitutes in case one person can't do it, then the document is still valid. Now, as I said before, attorneys have the same responsibilities as welfare guardians and property people. They are not allowed to just go and make decisions for you without consulting you. They are required to consult with you and to consult with other relevant people, and also to consult with each other if there is more than one person appointed. So they're also supposed to encourage you to make your own decisions as much as possible. And even if you have lost capacity, they are still meant to consult with you as much as they possibly can. If you aren't happy with an attorney and you have capacity, that means the welfare power of attorney has not been activated yet. It has to be activated by a doctor saying that you lack capacity. So something's happened to make you lose capacity. If you still have capacity, then you can change what's in the document at any time. You just need to talk to a lawyer. If you have lost capacity, maybe you had an accident or you're unwell, then you can still try to make changes, but that would need to be done through the court. Anybody, not just yourself, but also yourself, can apply to the court to have any decisions reviewed. So the decisions that are being made by the attorney, if you're not happy with them, you can apply to the court to have those reviewed by the court. And other people can apply as well if they're concerned that the attorney is acting improperly. Unfortunately, there have been a lot of cases in New Zealand of attorneys not acting properly and misusing their power. So you need to be very careful when you choose the right people, and you need to think hard. If somebody is trying to convince you that you should make them your attorney instead of somebody else, you need to think hard about why are they doing that? And if they are asking you to do that, then talk to your lawyer and make sure they understand what's going on, because the lawyer can help you figure out if it's a good decision to make that change. I hope this has been helpful. I would be very happy to have your feedback. The next video will be about wills. Thanks for listening. Bye-bye.